Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah. So, uya matinyana. Uya matinyana. Yeah. Uya matinyana. Oh, uya matinyana. Say, I call you Jireh. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. We are me one, come here. 1, 2, 3. I can breathe without you, say. I can breathe without you. I can move without you, Lord. I can move without you. Hey, who am I without you? Who am I without you? Say, I can live without you, yeah. I can live without you. I can breathe without you, Lord. I can breathe without you. I can move without you, yeah. I can move without you. Who am I? Who am I? Who am I? Who am I? Hey, who am I thinking now? Who am I thinking now? Oh, who am I thinking now? So, who yeah? Who am I thinking now? Who yeah? Who am I thinking now? So, who yeah? Who am I thinking now? Oh.
Hello, lovely people. Another Saturday is here with us, and we are live on BWTV, bringing you the community and the law. My name is Pamela Oakley, and I will be your hostess for today. This afternoon, we are going to have a discussion on how to successfully challenge a refusal of a skilled worker child application through administrative review. Charles Asma, a very knowledgeable solicitor at BWF Solicitors, is our resource person and guest, and he will be helping us delve into the nitty-gritty of challenging a refusal of a skilled worker child application through the administrative review process. And with that, I say, let's get into it together with the community and the law.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
When you've got Akasi. When you've got Akasi Pong, Minister OJ, Alexa Champong, and Diana Hamilton, what have you got? It can only be the return of Emmanuel Praise, brought to you by Alexa Champong Ministries. On Sunday, 26th of May, at the Pavilion, 143 to 145 Oxford Road, Reading. RG17UY. Doors open at 5. Tickets are £30 standard, £50 VIP, which includes your VIP seat, meet and greet and take pictures with artists, VIP snacks, water and drink, and an under 18 concession rate of £15. Get yours at alexichampong.com or call +44 744 741 7321. Emmanuel Praise with Minister OJ, Akasi Brimpong, Diana Hamilton, and Alexi Champong. You will be blessed.
Welcome once again to the community and the law. I am so excited to have you all around with us today. Another Saturday is here with us, and we have gotten to a point like this where I know you are also ready to learn with us. So, once again, thank you all for being here. This program is brought to you by the courtesy of BWF Solicitors, our trusted partners when it comes to legal issues. Whether you want to talk about immigration issues, family issues, or any other legal issues, and you want the trusted legal organization to support you, then you go to BWF Solicitors. They are located at the fourth floor of Anna House, 214 to 218 Tottenham High Road, Seven Sisters, London. They work from Monday to Friday from 9:30 a.m. in the morning till 6 p.m. in the evening. BWF Solicitors, we thank you for your kind support. And to all of you out there watching us today, we thank you very much for your time.
Hello, today, we are going for something more important. I'll hand you over to my host, who will take us through the next moment.
We are live on Facebook at BWF Solicitors and at BWTV. We are also live on YouTube at BWF Solicitors. Now, what I want you to do when you come online is let us feel your presence, as I've already seen so many people doing. So, as we feel your presence, I want you to click on the link, like the page, share the link so others who may experience and share in the knowledge that we are going to discuss today. All right.
Today's nugget is very important. My host is going to take us through the context or the fact of the nugget, after which we will bring you the legal interpretation or perspective. As we always do, my host will read and hand you over back to me for the legal interpretation.
All right, so the nugget for today is exceptional circumstances if you do not meet the immigration rules. Sometimes, even if you cannot meet some of the immigration rules, you may still qualify for residency if you can show that the Home Office refuses to grant leave to enter or remain. This would be a breach of your rights under Article 8 of the European Convention on Human Rights, the right to private and family life, because it will result in unjustifiably harsh consequences for you, your partner, child, or another family member involved. However, you must meet the suitability requirements. This is from paragraph Gen 3.2 to Gen 3.3 immigration rules. And the case law for this is a JACO. Yeah. So I'll hand you back to lawyer Charles Asma, who is going to delve into the technicalities and explain what this nugget means for us.
Hello, viewers and listeners. So today's nugget is very important because it borders on those who may be applying for leave to remain or even entry clearance as spouse of a settled person or a British citizen and do not meet the requirement. What I'm going to do on today's conversation on the nugget, of course, we've read the law, but we'll come back to this and we'll look at the root of this conversation. Producer is going to take or show us the policy undertone to this. So producer, if the policy is available, assist us with this. Thank you so much. So on this, we see the family policy. The family policy here is family life as a partner or parent. We are focusing on partner and the exceptional circumstances considerations. Producer, please take us to and the date for this policy. So down, you can see that it's fresh, 14th of February 2024. Please take us to page 25. Page 25. So page 25, family life as a partner, eligibility. So either 5 or 10-year route, you have the eligibility points. So we have the qualification aspect, that's the eligibility. You must be a partner, of course, so the relationship is set. Marriage certificate. Marriage certificate is never going to be an issue. Or living together as durable partners will again not be an issue. The main thing will be the financial requirements. So there might be financial requirement that you are not able to meet. So if you are not able to meet the financial requirement, then of course you have to have something that will assist you to still pursue the application. And that is what today's nugget is about, exceptional circumstance considerations. And that falls under the general provisions, So we have general provisions, 1 up to a number, but focus today is 3.2. General provisions 3.2. So producer, if you can scroll it down for us. So stay there, no, just up, yeah. So eligibility must be met by the partner, either 5 or 10-year route, unless they have consideration under either Gen 3.1 or Gen 3.2 or Gen 3.3. So producer, if you take us please take us down. We have the minimum age, go down, couples who have met in person, go down. We have genuine and subsisting relationship. Today I was having a conversation with somebody that, look, it's not enough to show that you are married to the person. It is equally important that the relationship is subsisting. So even if you prove the genuineness of the relationship, you have to prove the subsisting nature of the relationship. And how do you prove that you are living and continue to live with your partner? So that's a subsisting relationship. Please go down for us. Valid marriage, we are not going to discuss validity of marriage insofar as it's acceptable. Please go down. Intention to live together permanently. So all these points will be addressed in your application. Then we look at the fact that if you are any of these, you cannot really apply. We go down to EX1. We are not touching EX1, but it doesn't apply to partners per se. So we go down. So adequate maintenance, English language, please go down. Supporting documents to provide. Okay. Now, so we have all these requirements that you have to meet. Relationship requirement, financial or maintenance requirement. We have English language requirement, accommodation requirement, about 4 categories of requirement. But if you don't meet some of them, what do you do? So the law says that, please take us to the nugget. So the law says that if you do not meet any of these requirements, then you have to show that you fall under General Provisions 3.2, General Provisions 3.3, and also case law. The case law under, or for this discussion, is the case of Ajako. So Ajako 2017. Ajako is a Ghanaian, or of course, I'm sure he's still alive. So a Ghanaian who took the Secretary of State to court, and the case went all the way to Supreme Court, and it became a law that binds up to today. Now, it says sometimes if you cannot meet the requirement that we've gone through, you may still qualify. The word is may, provided that you can prove that there are exceptional circumstances that applies to you. And here it says that you may still apply if you can show that the decision to refuse will be harsh, and therefore it is harsh to the point that it will breach your family life under European Convention on Human Rights, Article 8. It will also be harsh to the effect that it will not be conducive for or appropriate for the family members that are in this question. And the family members here, we are looking at your spouse. There might also be children or stepchildren who are involved. Now you are making the application based on your spouse. But if there are, apart from the spouse, children involved, then they form part of the family. Now the test is, it will be harsh. The decision will be harsh in terms of the consequences for you and your spouse. And Jan 3.22, Jan 3.3 says that the harshness of the decision should point to the fact that if the party that is refused, the spouse who is making the application, is refused and removed from the UK, and the other partner, the other partner or the sponsoring partner cannot follow the applicant to the country of origin because they are British citizens, they have to remain in the UK, then what will be the consequence of the absence of this applicant in the life of this spouse or in the life of other family members here? And if there's going to be extreme consequence for the spouse, then the provision is saying that the caseworker must consider, think twice before refusing. Because if the case goes to court, the court will conclude that this should have been considered under the rules, Gen 3.2, Gen 3.3. Again, the case of Ajako says that if there is insurmountable obstacle in terms of the removal, so if you are going to be removed and the remover is going to bring untold hardship in terms of the family relationship you have, or the fact that there's going to be harsh consequence for the family members left behind, then the case of Ajako also says that the caseworker should consider, or the court must bear in mind, the family life right of this applicant. And we know that family life right is a protected right under the European Convention on Human Rights, and also the HRA Act, which is the Human Rights Act 1998. All these are clear, pointing to the fact that Article 8 is an enshrined right. So if you have Article 8 right or family life right, and therefore you don't meet and you don't meet the criteria or the rules for your application, you can rely on that to say that I don't meet, for example, income threshold, or I don't meet this particular threshold. However, refusal will be consequential or will bring hardship for me and my family, my wife or my spouse, my children, if there are children involved, then caseworker will not focus on the requirement, but the fact that there is an exceptional circumstance for this applicant. So, what is in this for you, for me, for anybody listening? What is in this is this, that if you do not meet the requirement as a spouse making an application under the rules, you can still apply, because if you're able to prove that there is exceptional circumstance and that refusal will bring untold hardship for your spouse, and if there are children involved, then the caseworker should ignore the requirement that you have not met and consider this in place of that requirement. Will your application succeed? We say yes. What if the caseworker says no? We take the caseworker to court and prove to them that the Supreme Court says that under the case of Ajako, the principle is that if one does not meet the rules, they should consider family life factors. And again, caseworker is put on notice within the February 2024 case working guidance that if the person does not meet, page 15, page 25, downwards, it says that if the person doesn't meet the rules, don't rush to refuse. Consider other factors if it is obvious. Good news for everyone.
Thank you very much, Lawyer Asma, for explaining today's nuggets. So we are going on a short commercial break before we come back to delve into the topic, how to successfully challenge a refusal of a skilled worker child application through administrative review. Once again, this is the community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345. Or you can send a text 07950-422-780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Welcome back, viewers and listeners. We are now ready for the discussion. Don't forget to share this program with your friends and family. You can also send in your questions to our Facebook and YouTube pages. Later on in our program, we are going to be looking at our quiz, which is based on the nuggets for today. All right, I am very privileged to introduce our resource person and guest, lawyer Charles Asma, to take us through the details and technicalities of the topic. Once again, the topic for today is how to successfully challenge a refusal of a skilled worker child application through administrative review. Lawyer Charles Asma, you are welcome to the Community and the Law today. How are you doing?
Thank you very much, Pamela. I'm doing very well. And how are you too?
I'm great. I am great.
Beautiful Saturday afternoon.
Very
And you are
beautiful.
glowed.
Thank you very much.
Yes.
So are you?
Thank you.
All right. So we have a very interesting topic today to discuss, which is how to successfully challenge a refusal of a child skilled worker visa through administrative review. Um, we are going to hand you, our guests, our listeners rather, over to you so you take them through this topic, explain it, and then we'll have a few questions to ask you later on down the line in the program. So
Thank you very much.
you are welcome.
Hello, viewers and listeners. Once again, pleasure coming your way. We bring you greetings, exciting one, of course, from the confines of BWF Solstice. As we always do, today we bring you another good tiding. And the tiding today is for parents who are experiencing despair and stress because their children's application for them to join them in the UK has been refused, and they've been refused on technical grounds. And today's focus is targeted, or actually the conversation is targeted at skilled worker child dependent applicant. Skilled worker child dependent applicant. However, because it's a child application, it also covers any child application under paragraph 297 of the immigration rules, which talks about children applying to join their parents in the UK. It could even be on the basis of EU, but we know that EU does not really talk about sole responsibility and this and that. With EU, straightforward is the best application ever. All you need to prove is relationship, and if you are over 21 years, dependency, nothing else. But any other immigration application, you have to show relationship in addition to the fact that you depend on that family member, whether you are, of course, even if you are still a child, you still have to show that they are responsible for your upbringing and upkeep, and it's exclusive. It's exclusive, and we'll talk about the exclusivity of that responsibility. So conversation is: one, you have a friend, you have a family member, or even yourself. Two, you are considering applying to bring your child to the UK because you are a skilled worker migrant and you were in the UK, or you've done your application before the changes in the law, and therefore you can bring your children to the UK. Are you considering what you need to put together? This conversation will help you, even though the application is not refused yet. Picking something from here will help you to know what to prepare so that you avoid refusal in the first place. What if you have done it? Could be your friend, could be yourself, could be anybody, but it's been refused. What do you do? Should you give up or pursue? I would say don't give up, provided, and the proviso is sound strongly in that provided you are very, very strong about the evidence, you don't have to give up, pursue it. And that is what we are going to talk about. How do I pursue if my child is refused to join me as a skilled worker dependent child? So I will take you through the rules or the provisions, after which we look at a sample refusal letter. Then we look at how to address that bit in terms of admin review. So what is the law, or what is the rule? The rule is appendix skilled worker. Appendix skilled worker. Under appendix skilled worker, there's a paragraph called paragraph SW32 capital A. Paragraph SW32 capital A, which talks about children applying to join their parents in the UK under appendix skilled worker. What does it mean? It means that the mother is a skilled worker migrant, and so the child is joining the mother. Or the father is a skilled worker migrant, so the child is joining the father. Or the stepmother or the stepfather is the skilled worker migrant, and the child is joining them in the UK. So the caseworker will look at the rule book. That's the backing scheme. So caseworker will flip to paragraph 32 capital A. What does it say? It says that you, the child applicant, if you want to join your mother or your father or stepmother or stepfather under skilled worker provisions, make sure that one, your mother is not the person that you are joining, the other parent is not in your life. A, dead. Two, absconded. That means they are alive, but you don't know where they are. So they have absconded from your life. Literally, they are absent. And the third one is that there is insurmountable or exceptional circumstance. An exceptional circumstance, it says that serious and compelling family circumstance that makes your exclusion from the UK undesirable. And the second limb says that there should be or there is accommodation and care in place for you. So that's the marking scheme. So A, you ask yourself, I'm joining my mother and my stepfather. My mother or my stepfather is the one on the skilled worker migrant program. Now, where is my other parent? That's a question for you, the child, because it is your application. Of course, this question will be answered by your parent who is making the application for you. So A, is your other parent dead? If the other parent is dead, then automatically the surviving parent has the responsibility for your upkeep. If the other parent is not dead, then you go to B. B says what shows that the one parent that you are joining is the one who does everything for you, and the law says sole responsibility. So what shows that this parent is the one with sole responsibility, i.e., making all the decisions, directing you in everything, having control over things that pertains to your life as a child. If it is, then you are okay. If not, you go to C. C says you have serious and compelling family circumstance. So let's take it that your parent doesn't have sole responsibility. However, your life is perilous at this point, in that there's something happening so seriously that if you are not relocated, it will be detrimental for your life. That is the serious and compelling family circumstances that makes your exclusion from the UK undesirable. Then you prove that there's accommodation, there is care. Accommodation and care, of course, it's easy to prove because they are objective in nature. We are looking at those subjective assessment that has to be converted from subjective to objective. So there's no death here of the other parent. If there's death, we have to show a death certificate. If there's no death, we go to B. Now, all these that we are talking about are also set out under provisions within appendix children, paragraph CH, paragraph CH, paragraph CH1. Now, paragraph CH1 or paragraph CHI, going further, it tells you that all the things we've said under 32A should reflect here. So it doesn't really matter whether we are applying what is under children, appendix children, or we are applying what is under appendix skilled worker. The bottom line is your mother or father that is sponsoring your application solely responsible? If yes, show it. If no, what shows that if you don't live where you are, you will die? Show it. That is the bottom line. Okay. That is why sometimes when they refuse the application, they will say that you've been refused under paragraph 32, capital A, with respect to appendix children, with respect to appendix children, and they quote appendix children. We'll go through and you see what we are talking about. Producer, if you are ready, please help us with the case study. The case study. So this is a letter from the Home Office to somebody who applied to bring their children to the UK. We didn't give you the first page because the first page contains personal information, and we are enjoined under the relevant provisions of Act, the Data Protection Act 2018, to ensure that people's personal data are protected. And so we don't need the personal information, so we did not bring you the personal information. What you need is from page 2, and that's what we are showing. So somebody will ask, what shows that this is from the Home Office? It is from the Home Office because it's the language they use. So somebody has been refused, and this is the letter. Your application has been refused for the following reasons. So they will tell you why. You applied for entry clearance as a skilled worker, and as we said, you are joining, the child is joining the mother or the father. In this case, the child was joining the mother and the stepfather in the UK. So the mother is the main skilled worker migrant, the stepfather is the mother's husband that traveled to the UK with the mother, and they are living together as husband and wife in the UK under appendix skilled worker. That means the moment the stepfather, that means there is biological father. And that is why the rule says, where is the biological father? And what shows that the biological mother is the one playing all the roles of a parent. So, you applied for entry clearance, your application has been refused. Simple, because you do not meet the rule. What is the rule? We have quoted the rule, and the rule is paragraph SW 32 capital A 1.1.1A. But the key thing is 32 capital A with reference to appendix children, and that's what I said earlier on. In order for you to meet the requirement of paragraph children, CHI 3.2 of appendix children, both of your parents must be either applying at the same time or have permission to be in the UK. So let's check. Pause there. The rule says that both parents are applying at the same time or both parents have permission in the UK. We know that in this case, the biological mother has permission to be in the UK because they've been given the visa and the skilled worker. The stepfather is also in the UK with the biological mother. So let's read the law. Both parents. Are both parents in the UK? The question is, what does the law mean by parents? And these are biological parents, not the other half parent. So biological parent must be either applying at the same time or have permission to be in the UK and you are joining them. We know that this child was not joining both parents, and therefore one parent did not have permission to be in the UK. While you have applied as the dependent child of your mother, which is half parent, your father has not made an application for entry clearance, and therefore both parents have not made an application or do not have permission. I have considered whether an exception to CHI 3.2 may be made under the grounds that your mother has sole responsibility. So the exception to this rule is that there is sole responsibility or there is exceptional or serious and compelling family circumstances. So the exception, sole responsibility for your upbringing as outlined under CHI 3.2. And that is the test, sole responsibility. We always say sole responsibility, sole responsibility. Sole responsibility because both parents are not applying. We go down, it says that I have considered your application with reference to Section 55 of the Borders Act. Section 55 of the Borders and Citizenship Immigration Act 2009 says that if the caseworker is making assessment of a child application, they have to consider what is best for the child, what we say the best interest of the child consideration. So they considered what is best for the child. So they said that in support, I have considered what is best for you with respect to promotion of your well-being and safeguarding of you as a child. In support of your application, I have seen that you provided the marriage certificate. Of course, marriage certificate will show that the mother is married to the stepfather of the child. But in this case, we don't really need marriage certificate to prove that the child can join their biological mother. You only need marriage certificate if the child is joining the stepfather who is in the UK with their biological mother. What do I mean? If the stepfather is the main skilled worker applicant, then the child who is joining that skilled worker applicant stepfather must prove that the stepfather is married to their biological mother to make them a family unit. But in this case, the mother was the one who holds the trump card, which is the skilled worker visa. So if the mother is the main applicant, whether you add marriage certificate or you don't add marriage certificate, it doesn't really add anything to the evidence. Birth certificate is relevant because you are proving that this is your mother. So relationship is met if you are a child with by either birth certificate or DNA. We know that DNA is not compulsory, and therefore I'm not going to say here to tell you that add DNA and that will work. If you want to add DNA, it will only add value to the relationship that you want to prove, but it's not compulsory. However, if sometimes birth certificate is picked up and they say that how come a child who is 11 years, the birth was registered just last year when they were about to travel? I mean, there's no law that they can't register birth last year or when they are more than 10 years or when they are 11 years. But technically, in the UK, the law says that once a child is born, their birth must be registered within a short time. If you go to Ghana, the Birth and Death Registration Act 2020, Act 1027, it tells you that once the child is born, they must be registered within 3 months. So this child whose birth was not registered within 3 months, and it is years before the birth was registered, how do we prove that the birth certificate is still valid? Then they have to get a letter from the registrar of birth to prove that their birth was registered within the law, because the law says that if you don't register within 3 months, you can register later with explanation. So if you registered later with explanation and there's the verification letter to show that birth certificate is genuine or is valid, that's fine. But it's not enough to provide birth certificate, because birth certificate does not prove that you are the only one responsible for the child. We go to so the person also provided mother's identity card. I mean, whether you add identity card, of course, you have to add identity card so that we know that this is the person. So they provided the passport. I'm sure they also added Ghana card, but it's not whether you added or you didn't add. The test is sole responsibility. The Home Office wrote to you, and it's very important. Under the evidential flexibility rules, the caseworker is required by law, where in doubt, to ask for further evidence or clarification before they decide. So they wrote to this person 20th of March 2024 requesting any further evidence or information, document which would like to be considered, which they would like to be considered, and that in line with the provisions of paragraph CHI 3.2. You were given 10 working days to respond, and you did respond. So they were not late. But was the response targeting the question? The question is, what else do you have apart from these three things you've given us? We know that marriage certificate is really not necessary. We know that birth certificate is important, but it doesn't prove sole responsibility. We know that the mother's passport copy is important, but it doesn't prove sole responsibility. So technically, the evidence they provided initially did not prove anything. So they asked them to bring something to prove the case. So they responded by sending letter from stepfather and mother, and that's the consent letter. Consent letter should have been added anyway at the time of application. So the caseworker was lenient to say, bring something else. They didn't tell them to bring anything specifically. They said, bring whatever you have to prove your case. And they decided to send consent letter, family photos, and father and stepmother's residence permit. This should have been the other way around. It's supposed to be mother and stepfather's residence permit. The reason why I'm saying this is that this application is a live application. I've just sent the admin review application and the grounds and the supporting evidence to the Home Office. The child in question, the mother here is the biological mother. Actually, there is the stepfather, which is the stepfather, or not the biological. So the Home Office got it wrong. The reason why the Home Office got mixed up is that there is one child, which is for the mother, and two children for the stepfather. So there were three children involved. But when they came, it was only possible to apply under admin review for one of the children, because the other two children, the case is so dire that the evidence is weak. And on assessment, my best advice under the principles we have from SRA, best interest of client, is that if you do this, this is going to happen, your case is weak. So they decided not to pursue it. So they only pursued for one person. So principle 8 under SRA rules says that whatever we do, we should do it in the best interest of that client. I have considered the evidence supplied, in particular the letter you sent to us. Whilst I know that this letter lists that she gives full consent for you to travel to the UK, you see, that is why I'm saying that caseworker got it wrong. It's rather stepfather, not stepmother. Now, so the biological mother gives full consent for the child to travel to the UK to reside with them. I am not satisfied that this is evidence that your mother is solely responsible. So you see, consent letter doesn't show that you are solely responsible, and therefore you meet the rules. We go down, please, producer, if you have the second part. Thank you. As such, I'm not entirely satisfied that this represents an accurate reflection of your circumstances. Therefore, I am satisfied that you have not provided evidence to show that your mother has sole responsibility. I also know that there has been an overall lack of evidence and official documentation supplied to support the fact your father is your sole responsible parent. Here, because there were other children involved, the caseworker was all over the place. Don't mind them, they get it wrong sometimes. So let's leave that. I have also considered whether there are any serious and compelling reason. So you see, the caseworker is saying that you, this child, you don't meet sole responsibility threshold. So let's go to the third part, which is C of appendix children, CHI 3.2C. It says that if you don't meet sole responsibility, show that there are serious and compelling family circumstances. So the caseworker said, I've considered serious and compelling family reasons why it should be granted a visa to join your mother in line with C. However, I'm satisfied that there is no serious compelling family reason to grant you entry as a child. I see no reason why you cannot remain, and this is stressed. I see no reason why you cannot be where you are. I see no reason why I should allow you to be relocated and therefore stay where you are. Refused. Now, we are going to court, but is this person given opportunity to go to court? Let's see whether that was right. Please go down for me. Next steps. So the person stayed there for us. The person is refused under paragraph SW32A 1.A with respect to appendix children, paragraph CHI 3.2. Next steps. You can seek admin review if you think we got it wrong. There's no appeal right. So, and the skilled worker applications do not have appeal right, only admin right. Now, admin right is important because if a caseworker is making a mistake, under rules of, under constitutional provisions or public law provisions, an agent of the government must be seen to be doing the right thing. If they get it wrong, we can seek a review of their action. And that's why there's admin review for them to review. If after admin review it's still not working, the person has a right to go to court under judicial review. This is not an appeal. We call it judicial review under public law provisions. So what do we have to go to court? I mean, to go for admin review. So as I told you that we have sent the application for admin review. So what did you say? What did you do? What did you tell them? How did you prove that they got it wrong? Okay. And this is where we now approach the law. So what they are saying is that the fact is not enough. If the fact is not enough, what do we have to say that it doesn't matter how much we have in terms of the factual evidence? Case law or the other laws support the fact that it doesn't matter how much you have, under the circumstance, it should be considered. And that is our argument. So the first thing we are looking at is to apply. The question is, how do you successfully challenge this application? You are given 6 weeks, and please, 6 weeks is 6 weeks. If you are doing or sending the admin review after 6 weeks, they will ask you, are you doing it in time or on time? In time means you are applying ahead of 6 weeks. On time means on the 6th, just on time. 28 days, the last day, you can still bring. Or long before that date, you can bring. After that date, you are late. And you have to give reasons why you are late. If you don't have a reason why, you should still be allowed to send your admin review application. It will be rejected because it's not valid in time. Right. So we applied in time. You pay £80 fee to the Home Office. The application is online. You print and add the checklist. You also have to add reasons why you are going for admin review. Admin review simply means that the caseworker got it wrong. They did not either understand what sole responsibility means, and so they misinterpreted it, misapplied it, and got it wrong against the applicant. So we are putting them into perspective and set the record straight for them. Or they got it right, but they didn't apply or understand the evidence that the applicant provided, and so they got it confused. And so they didn't know that the evidence that the person gave is actually what is required. Either way, we have to point it out. Once you apply within 10 days, you have to send your grounds, the reasons supported by evidence. The person does not have anything that was not previously submitted. What it means is that what the person has are the things we have on record or in this refusal letter. Some people may have money transfer receipt. Money transfer receipt may show that you look after the child, but not necessarily that you are the only one in the life of the child. We are looking at how to get it right, how to successfully do this application. So in this case, I told this person that these are your chances, going ahead or not going ahead. The person said that it is better to explore the chance I have, no matter how limited it is, than giving up. So we are pursuing on the basis of the instruction. So what else could we have added? Family photos, letters from school, letters from church, letters from hospital that the child is sent to whenever the child is unwell. A range of them, not just the year in which the child is about to travel, you put together. It has to be a range. So the question we pause to ask is, how long has this mother been in the life of this child alone? What happened to the other parent? The instruction is that the other parent is not dead. Because the parent is dead, you have to provide the death certificate. And that will be SW32A, capital A. The A, even though the A is in there, we have A, B, C. A is the death certificate, B, sole responsibility, C, serious and compelling family circumstance. We are looking at B because the mother says she's solely responsible. That means the father is not dead. So where is the father? The child is saying, I don't know where my father is. I grew up to be told that my father abandoned me. So I don't know my father. Okay. So what shows that your mother is the only one doing everything for you? Let's go to school and ask them. So we go to school, and school has given nice evidence that since knowing this child as a pupil or a student, we know that the mother is the only one who has been attending parents' evening, who has been given permission for the child to be sent on school trips, who has been discussing matters to do with the child progress. Everything is all through or with the mother. And therefore, apart from the mother, we don't know any other parent in the life of this child. Okay. The child we know or happens to have a private tutor. The private tutor has also put in evidence that I have been teaching this child maths, English, science, whatever, since this year. This is about 5 years, 6 years. Actually was instructed or asked by the mother to help the child. All these years, I've never met the father. I haven't heard anything about the father. The last time I was curious to ask about where the father is, since it is only the mother who is doing everything, and the mother was so emotional about it, but was able to tell me that, oh, the father abandoned the child or abandoned the pregnancy or has not been in the life for a long time now, and blah, 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 blah. So the personal tutor or the extra classes teacher is also giving evidence based on what he knows. Some people will just say that, and so please let him travel to join the mother. You are not there to say whether the child should travel or not. You are only saying that this is what you know. That is your professional judgment. And the lawyer or the person will use the evidence to support the application. We also go to the church. Sunday school teachers, the church pastor or leaders are also giving the same stories, similar to what the school is saying. We also go to the hospital where the child is actually usually sent for treatment. There's also evidence letters from the hospital pointing to the same direction that they never know about a father in the life of this child. It's always been through and with the mother in terms of instruction for treatment, the medication, whether they should give the medication or not. It is the mother who gives the permission or consent. Everything else is through the mother. And even when the mother was traveling, the mother gave instruction that I am traveling abroad. My child will be living with my mother. My mother is weak and old. She's about 60, 70 years old and is already going through some medical issues. So please bear with. Whenever she brings the child, make sure that you contact me if there's anything else that I need to do. But my mother will be bringing the child for medication or for review. You see, the doctor is confirming that the mother left instruction and all this. The doctor is confirming that the hospital liaises with the mother for permission as to whether to operate the child, if it's necessary, whether to give certain medication, whether to do this or whether to do that. Even the church and a host of other evidence. We put all this together and we say that what we have tells a story about a child who has no father and a child whose mother has been the only person doing everything from this corroborative evidence we've gathered from independent sources. So it's not enough for the mother who is looking after the child to write a letter to say that, you know, I am old and so I can't look after your child again. Please come for your child. It's not enough. There should be corroborative evidence. And of course, the person looking after the child is either due to illness, old age, or what have you, is unable to provide proper physical care for the child. Because apart from physical care, the mother is the one providing everything: financial care, emotional care, psychological care, and everything else. And what has the mother got to show that she's still providing psychological care and emotional care? She's been communicating, calling home, sending text messages, checking up on the child. She's been going to visit the child. Even when the person entered the UK, at least they visited once to check up on their child. It shows that they are the only one in the life of this child, and that the person whom they have entrusted the physical care of the child to is not able to do everything. So they go to check up. They always do this, they send money, they do this, they do that. In addition to the letters from school, from church, and all that. Now, this is the fact. We then have to look at the law. What does the law say? So case law tells us that in assessing sole responsibility, don't be shallow in the assessment. What does that mean? Then we point out to the law. There is a case called NA. NA talks about reasonableness. Reasonableness assessment is about the best interest of the child, more about serious and compelling family circumstance proof. However, it can also be mentioned under sole responsibility. What does the law say? The law says that is it reasonable for this child to remain where they are if the mother is the only one making all the decisions in terms of control and direction of the life of the child? Why is it not reasonable? It is not reasonable because the mother has to travel there, which is logistically impossible all the time. The risk of traveling by air because you have to go and visit your child. Again, the financial implications, the cost. Again, we are looking at how the emotional support is provided by phone, by WhatsApp, and by modern technology. Yes, modern technology is there. You can see the child, have a video conference. Hello, how are you? Have you eaten? Oh, okay, be good. Okay, bye. You go and sleep. You'll be thinking, oh, so what's happening to my child? So you can see that the emotional support you only providing to an extent. You cannot do it fully if the child is living with you. Up to the point that you could have been given if the child was living with you. So the argument is that it is reasonable for the child to join the mother so that the mother can do all this every day, all the time, face to face. That is one point. The second point is that the evidence should be assessed not in vacuum, but in context. What is the context? They are saying that the evidence is not enough. But case law, for example, the case of Imaju, the case of Imaju says that when assessing sole responsibility, you have to look at the time factor. We are not looking at 10 years. You are not looking at 100 years. You are not looking at 5 years. And therefore, you say that how come for 4, 5, 10, 6 years, you haven't done what you claim you have been doing? So the caseworker is only thinking that sole responsibility means long time. Because the mother has said that the father has not been in their life for about 6 years. But the evidence there does not show that it's 6 years. But what the mother is saying is that the grandmother of the child, which is the mother of this mother, is helping with the care of this child. And therefore, even though they only see for 2 years, or they only see for 1 year, the question is, does it really matter the time? So Imagine says that it doesn't matter the time. So it's about qualitative assessment, not quantitative assessment. Quantitative means you are counting how long the woman or the parent has been solely responsible. But Imagine says that it is not how long, but how quality it is. The quality means that the mother is being able to show that she's the only one providing control and direction in terms of the well-being of the child, the care of the child, the safeguarding of the child. So what has she done? She's been calling, she's been sending money, she's been traveling to visit, she's been doing all that. Is that qualitative? Yes. A good parent is the one who will still be thinking about the child and therefore will still be checking up, will still be doing what they have to do, even in the midst of that constraint. So Imagine is saying that even if it is 1 year, and we can see that it is quality, it is enough. So my argument is on that of Imagine principle. That's point one. There's another case called Slowly. Slowly also says that in assessing sole responsibility cases, you also have to check the evidence, test the evidence, and whether the evidence is objective. Again, you have to check whether on a balance of probabilities, it is understandable that this woman or this parent is the one doing everything. So what do we have? All the evidence we put on the table. If we're able to put all together corroboratively and say that it all points to the woman doing everything, then there is sole responsibility. You see, sole responsibility is not about 1 plus 1. It's not quantitative that you say that take. It's so subjective that we are bringing subjective assessment into objective assessment. And the only way to make it objective is to bring the evidence together and put them on the balance. And if we put them on the scale and we assess that, putting all together and looking at the context, it points to the fact that the woman is solely responsible or the father is solely responsible, so be it. What then happens is that the caseworker will look at the argument we have made. Again, we are looking at the policy. The policy that the Secretary of State or the government has given the workers, the caseworkers, is that when they are assessing sole responsibility cases, they have to also consider the family interest. The family interest. So we also point out that in making a decision whether to accept our argument or not to accept our argument, we're also putting you on notice that there is Section 55 consideration, the best interest of the child. This is a mother who is in the UK with a stepfather. The stepfather was in the life of this child because the mother married the new husband, and the new husband became a stepfather to this child. They were living together with their child. They moved together to the UK, or the stepfather joined the mother in the UK, and now there's no mother, there's no stepfather, and so the child is technically alone. Is this good for the family? Is this good for the child? And we say, think about it. Section 55. We also move on to look at other considerations. Article 8. We are disintegrating the family. We are not saying that we have met the sole responsibility or not, but what we are saying is that they have to consider all these points. Then, when you are doing this, what you are telling the Secretary of State is that there is sole responsibility. Your mother is the one looking after the child, or a friend is the one looking after the child, or somebody somewhere is the one looking after the child. And they say they cannot do it anymore. And so the child is going to be left alone. Who is going to look after the child? So we are now moving from B to C. So even though the argument is about sole responsibility, there can also be element of serious and compelling family circumstance. So the serious and compelling family circumstance is saying that if the child's situation is such that there's nobody else, and there's element of neglect in the life of the child by whoever is temporarily looking after the child, we have to put it in for consideration. The question is how to successfully challenge child application refusal under appendix skilled worker by way of judicial review, admin review. So the admin review means that go to the Home Office, tell them that they've made a mistake, and point it out to them. You don't just tell them that you've made a mistake because you didn't look at the evidence. You point it out to them that even if they think the evidence is not enough, there is law which supports the fact that it's not about how much, but it's about how good and quality it is to be considered. We'll take a commercial break. We'll come back to continue the conversation. Stay put.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the fourth floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
When you've got Akasi Pong, Minister OJ, Alexa Champong, and Diana Hamilton, what have you got? It can only be the return of Emmanuel Praise, brought to you by Alexa Champong Ministries. On Sunday, 26th of May at the Pavilion, 143 to 145 Oxford Road, Reading, RG1 7UY. Doors open at 5. Tickets are £30 standard, £50 VIP, which includes your VIP seat, meet and greet and take pictures with artists, VIP snacks, water and drink, and an under 18 concession rate of £15. Get yours at alexchampong.com or call +44 744 741 7321. Emmanuel Praise with Minister OJ, Akasi Pong, Diana Hamilton, and Alexa Champong. You will be blessed.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you, and they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Welcome back, lovely viewers. Thank you very much, Lawyer Asma, for your very detailed explanation on the topic. This is a very, very interesting topic, and I know it's one that is a concern to many people. I know that there are many people, all of our viewers and listeners, who have questions for Lawyer Asma. So we are now going to take questions that have been sent to us by our viewers and by our listeners. If you also have any question, don't forget to ask under our comment section on our YouTube and Facebook pages. The phone lines are also now open. you can call us on 0208 493 7345. I repeat, 0208 493 7345. Producer, can you give us the questions? All right, so the first question we have is from Asante Richard, and he says, please, why is it that appeal cases keep so long for a decision? Lawyer Asma.
Right. I'm not sure whether it is the decision itself or the process to the process of the appeal. The appeal guidance says that from the date of your appeal up to the date of decision is about 48 weeks. So the question is yours 48 weeks? If it's not 48 weeks, then the court is still operating within the guidance. If it is more than 48 weeks, the thing is this. After decision, the judge must write the judgment and make it available to the court clerk. And the court clerk will share with you, the appellant, or through your lawyers. And also the Home Office will have their copy. Let's assume that the case is heard and decision is still not in. Normally, once the case is heard, the judge will say, my decision will be available in 6 weeks or 8 weeks. So you're talking about 2 months. Add 2 months to the 48 weeks. That is 8 plus 48, 56. So 56 weeks is more than a year, because a year is 52. So you see, why it happens is because there are so many appeals in the court. Before just a few, now a lot. And so the judges are not many, and that is prolonging. It might also be that yours has been decided, but Home Office has not given you the visa yet. We call that implementation. Again, it takes time because the Home Office will then add yours to the queue for you to wait to be called to send the passport to them. But if you think that it is genuinely delayed, call the court to ask them or get in touch with the Home Office to follow up.
Okay, thank you very much, Lawyer Asma. All right, producer, next question. All right, we have Grace Annabelle who says, can I apply for a fee waiver on an application made outside of the UK when bringing my son? I am on a family visa, 10 years parents' roots. Okay.
Right. So there is fee waiver concession for family life applications, which fall under human rights applications. So if yours is one of them, check to see. If it is, you can apply for a fee waiver, but you have to prove that you cannot pay the fee. That's why you are seeking a waiver.
Okay, so our next question is from Bernard Tete, and he's asking, please, how long does the court or Home Office take to respond after submitting your ASA and bundles? Okay.
Right, so once you've sent your ASA means appellant skeleton argument. So that is the argument you are going to have in court through your barristers. The bundle is the evidence you have to rebut the refusal reasons or presumptions. Once you do, okay, so the position is this. You are refused, you make your application to court for appeal. 28 weeks, 28 weeks, 28 days, Home Office must provide their evidence. Then 42 days, you have to provide your evidence. Sometimes we may be waiting for the Home Office. If I say we, the appellant may be waiting for the Home Office to send their evidence, which is their position, before yours. But if yours is gone, then you don't have to worry, because you're asking how long does the court or Home Office take to respond after submitting your evidence. You just do what you have to do and leave the rest to court, because it's a process. If 48 weeks is over and you have sent your ASA, your bundle, and the court has not given notice of hearing, then you have a concern. But if it is still within 48 weeks, and you have done everything you have to do, what I would say is that sleep, eat, rest. The court will give you notice, then you go and speak in court. But if you still think you want to know what is happening, call the court, and the court will respond to tell you that you will get the notice.
Okay, so our next question is from Richie Jogbe, and he's asking, can skilled care workers apply to do nursing courses with the NHS?
So this is like asking, if I'm in the UK with a visa, can I go to school? Yes, you can go to school, just that you will not be treated as a home student. So you have to pay your fees, and you have to be able to meet the requirement of that studies. So it says nursing courses with the NHS. I don't think NHS has, or NHS does not run nursing courses. NHS does not run nursing courses, so you have to apply through a university that offers nursing degrees. So that's what you have to do.
Okay, then our next question is from Rafcon. He's saying thank you for the great job. So thank you, Lawyer Asma. He's saying he has overstayed his visitor's visa since 2019. His wife recently got British citizenship by descent via her late father, and they have been married for 16 years when she moved to the UK. So his question is, can I apply for spouse visa in country application FLRP?
Is there a child involved? If you go back, did they say they have a child as well?
No, he's
There's
not
no child.
mentioned.
All right, so there's no child in here. So you're just applying as a partner of a British citizen. So you have to prove the relationship. You have to prove that you've lived together for at least 2 years. If you are not married, the rules now say that you don't necessarily have to have lived together to prove that you are in a durable relationship. All you need is evidence that there is a relationship. So yes, you can apply to remain in the UK with your British spouse. And that is the conversation within the nugget for today. The question might be if you have suitability issues. So if in the course of your overstay period, you committed an offense or there's something hanging around, then that might trigger a refusal under Part 9. Otherwise, you should be fine. But you need a thorough advice before you decide what to do.
Okay, so I would like to remind us once again, if you have any questions, you can ask and put it under our comment sections on our Facebook and YouTube pages. You can also call us on 0208 493 7345. The phone number is 0208 493 7345. Okay, so we have another question from Nana Yao. His question is, please, does one qualify to apply for a provisional license for ID purposes whilst waiting for his 20-year route application outcome from the Home Office?
I know that if you're applying for a provisional license, they will ask you to provide an ID or leave to remain. Check. Can somebody do it? Just go on the internet and check. This is not law per se. But what I do know that there will be limitations. So if I were you, I will wait. Once my card comes, I will then apply because they may ask you to provide your BRP, which is not ready yet. But just go on the internet and ask. Requirement for provisional license, driving license application, and you will see the requirement.
All right, thank you very much. We have another question. Producer, if you could give us the question. All right, so we have a question from Abubakar Salifu. He says he is doing a spousal visa application for his wife to come and join him in the UK and wants to know how much the application fee is. He wants to know if it is £1,040 or £1,840.
Okay, there is IHS fee and also visa fee. It's not just a visa fee. I will not be able to give you the absolute figure, so I will not even attempt. But what I will say is that the fees are available on the government website. Just Google spousal visa application fee and add the country where your spouse is applying from. It will show up. The last time I checked was before the changes, and I always want to be sure, so I always check the application fee paid by the application that I made. And the last one was when it was about $4,700 for everything, but I know it's gone up. So let's just be careful before, so you can check. Otherwise, you can phone later next week. We'll be able to give you the exact figure.
Okay, our next question is from Dominic Tre. He says, "Hello, my son is not bearing my surname. Please, is it going to affect him when I am applying for a British passport for him? My status is indefinite leave to remain, and my son was born here in the UK."
The law says that you only need to prove that this is your son, and the proof is the birth certificate. The birth certificate will have your name, which will link to your passport, your son's name. It doesn't matter how you have named your son. It is nobody's business. So that's not going to affect you at all.
Okay, thank you. Okay, so we have a caller. So, good afternoon. Can we get your name and your question, please?
My name is Kay, and my question is this. Um, it's quite a long one, but I will still try and ask it.
Okay.
So I'm asking on behalf of someone. So she had a child with someone. The child has been taking care of the father for about 9 years.
Okay.
The child was brought to the UK in 2022 for a visit with the dad, and then they went back because it was just for holidays. But a few months after, dad did DNA on the child, and they realized that he is not the father to the child.
Okay.
Currently, the child's mom got married last year to someone else who is now applying for the skilled worker visa. So my question is, they're trying to preempt what the lawyer was saying. So the question is this: now that technically there's no biological father in the picture, what would be the right approach to deal with this application?
Okay.
Right. Are you on the line?
Yes.
Would you like us to deal with this on this show? Or you want us to deal with this face-to-face or at a bespoke level? Do you want general response or specific response?
So you can give a general one.
Okay.
I'm happy to contact you on the side to take it from there.
Right. Now, as you said, there's no relationship here. So who is making the application to come to the UK?
So the stepdad is making the application.
The son. The stepfather.
The
So stepfather is applying to join who?
No, the stepfather is making the
Application for the child.
Skilled worker application, and then the mom and the child will be joining as dependents.
Okay, all right. I want to know the roles that each one plays. So my question is, who is the applicant? Is it the child and the mother? The people who are applying, who's going to make the application to come to the UK?
The child and the mother, yes.
The child, yeah. The applicants are child and wife, yeah?
Yes.
But this child is a stepchild, I suppose.
Yes.
So what you are telling us is that the mother is applying to join her husband in the UK under skilled worker, right?
Yes.
And the mother wants to relocate with her child, right?
Yes.
And the child is under 18, right?
Yes.
That's the conversation we had today. Because there's half parent, and you agree, don't you? Half parent.
Yes.
There's a half parent because there's step there. Because there's half parent, they will say that both parents are not coming to the UK together. So the child must prove that the mother who is moving to the UK has sole responsibility over his life.
Yes.
Yeah, that's the answer.
Okay. Okay. So what was trying to show was at a point there was a father involved, and then the father even brought the child here to the UK. So the child is even known to the Home Office, if you put it that way. But now that the DNA is showing that there's no relationship, would that be that extenuating circumstance to show that the child will be left alone if the mom comes here, because the child will not get the support from the one that used to support them as the father?
Well, those emotions are aside. What it is that there is a child who wants to join a stepfather in the UK, and this child is going with a mother. So the mother's application will be assessed as a spouse. That is likely to succeed. But the mother just has to prove that I am married to this man, and this is the evidence that we've lived together for at least 2 years. Are you with me?
Yes.
The child application the child application is 50-50 because the child will have to show that let's not go into the biological the father, the DNA and all that. It is because of that, that's why the child is joining the stepfather, isn't it?
Yes.
And therefore, is the mother solely responsible? If the mother is not solely responsible, application will fail unless the child can prove that even though there's no sole responsibility, leaving him alone in the country will affect his well-being and life generally.
Okay. Okay. All right. That's
Okay.
fine. And yeah, it's fine. Thank you
Okay,
so much.
thank you very much for your call.
Okay. All right. Thank you.
Bye. Okay, thank you, Lawyer Asma, for answering all the questions. Thank you, viewers and listeners, for bringing in your questions. We will now take a short break, and when we come back, we will look at our weekly quiz and some of the answers you lovely people have provided to the question of the quiz.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, lovely people. At this point, we have reached our quiz time. So, the question for the quiz was Nee Brown, an illegal migrant, is married to Agatha under customary law. Agatha is a Ghanaian citizen with limited leave to remain based on her child. Agatha has a 6-year-old British son named Lucky from her previous relationship. Nee's application for leave to remain was refused because he is an illegal migrant, and the Home Office said he was not a parent to Lucky, although Agatha's previous partner was deceased. The question now is, Nee wants to appeal the decision to the tribunal. Advise me. 1. He can rely on the exception under Appendix EX1A or B. 2. He can rely on the exception under Gen 3.22 or Gen 3.3 because of his human rights. And 3. He can rely on his wife's limited leave to remain under Appendix FM. We are now going to look at some of the answers our viewers and listeners have brought to us in relation to this question. So we have George Asari, who thinks the answer is number 2, which is he can rely on the exception under Gen 3.22 or Gen 3.3 because of his human rights. And then we have Josephine, who also thinks the answer is the same, number 2. Then we have Doreen Mokia, who thinks the answer is number 3, which is he can rely on his wife's limited leave to remain under Appendix FM. We then have Gifty Echa, who thinks the answer is number 2. All right. We have Kelvin Asamoah, who also thinks the answer is number 2. Clearly, we have a lot of our viewers thinking the answer is number 2. Okay, then we have somebody who thinks the answer is number 3. He can rely on his wife's limited leave to remain under Appendix FM. We have another person, Jessie Apia, who thinks the answer is number 3. And Martha Nugent thinks the answer is number 2. Clearly, there's a battle between number 2 and number 3. We also have Mavis Amwa, who thinks the answer is number 2. Okay, and Foster Siama, who thinks the answer is number 3. So looks like nobody's going in for number 1. And clearly everybody really thinks the answer is either number 2 or number 3. We will go to Lawyer Asma, who is now going to give us the answer. So hold tight and let's see what Lawyer Asma has come to tell us the answer for our quiz question is. Lawyer Asma.
Thank you very much, Pamela, for the yeoman's job. So, viewers and listeners, the test borders on the nugget, exceptional circumstance. So, this is somebody applying, and of course, the wife is there, there is a stepchild in there, and application is refused. What do we do? EX1 and Gen 3.2 are twins with differences, because they all borders on exceptional circumstance for those who don't meet the rules. Obviously, if your wife has limited leave, you cannot use the limited leave unless they have indefinite leave. So 3 is out. So it's between 1 and 2. But the difference between the two is this. EX1 is for somebody who is applying based on their biological child. So if the child is yours, you are using EX1, special direct access provisions. So you have direct access to your child. There's exceptional circumstance that if you are removed from the UK, it will affect your child. Even though your child lives with a mother somewhere, you are playing active role in the life of the child. EX1. Gen 3.2, 3.3, Ajaku say that if you are applying as a family unit, and you are part of that family. So this is somebody who lives with the wife and the stepchild. Because the wife has limited, they will rely on the stepchild per se, but the application will go as a partner, but the consideration will be the stepchild. So the stepchild is very chosen. What will happen is that if they refuse, the argument will be that hang on, you want the man to go. What's going to happen to the wife and what's going to happen to the child, the stepchild, in terms of care and support, and therefore consider human rights. And so the answer is 2, Gen 3.2, 2, and 3.3. And the Ajaku play come into play.
Okay, thank you very much, Lawyer Asma. So, as we have seen, the answer is number 2. So, at this juncture, I want to thank all our viewers and our listeners for tuning in today to watch the community and the law and learning with us on how to successfully challenge a refusal of a skilled worker child application through administrative review. I would ask Lawyer Asma to give us a brief summary of today's discussion.
Thank you, viewers and listeners. So to sum it up, if your child's application is refused under sole responsibility, skilled worker application, don't give up. Call on us or call on yourself and make an application for admin review, because it might not be the end of it after all. Because the law says that if the caseworker is not able to interpret sole responsibility provisions and apply it well, you have a case in law to seek admin review for them to correct it. Even if the admin review, they come back to say that we have maintained the refusal, you still have case in law to go for judicial review, where a court will make a final determination to say whether you are right or they are right. So that is what we'll leave you with. But what we are saying is, if we are making an application, think about the provisions. Is the child's is the child's other parent dead? If dead, add the death certificate. If not, is the parent who is bringing the child having sole responsibility? If yes, how do you prove it? So before you consider the application, take your time and go through the project properly and make sure that you tick all the project milestones. Then, if the sole responsibility is weak, add C, which is serious and compelling family circumstance, where we'll have social workers report or the police report to confirm the fact that the child's situation is dire, and so it is better for them to join their parents. If you pull all this together, you will succeed at the application stage. If it doesn't, then we are able to seek admin review for you. But the game is all about evidence, and therefore make sure your evidence is solid to be able to go to the end. Thank you and enjoy the rest. I'll pass you over to my host.
Thank you very much, Lawyer Asma. I hope we have all learned a great deal on how to successfully challenge a refusal of a skilled worker child application through the administrative review process. All right. So, once again, if you have any family matters, immigration matters, or any other legal matters, you can bring it to BWF solicitors. They are located on the fourth floor of Anna House, 214 to 218 Tottenham High Road, Seven Sisters, very close to the Seven Sisters tube station. Their phone number is 0208 493 7340. They work from Mondays to Fridays through 9:30 a.m. in the morning till 6 p.m. in the evening. Thank you, our lovely viewers and listeners, for spending your Saturday afternoon with us, and we hope to see you again next week, Saturday. It has been the community and the law, and I have been your hostess, Pamela Oakley. Have a great weekend.